Hello and welcome to this discussion on the impact of outcomes-focused regulation on in-house lawyers. My name is Will Long and I'm Head of In-house Development at LesixPSL, and I have with me Bruce Macmillan, General Counsel of the Legal Services Board, the oversight regulator for the legal profession in England and Wales. On the 6th of October 2011, the Solicitors Regulatory Authority's new handbook, Outcomes-Focused Regulation, came into force. The new regime has a significant impact on in-house lawyers and the way they manage their legal departments. Bruce, thanks for joining me. Several of our in-house customers, including the LesixPSL In-house Advisory Board, have asked us some questions about the background to and the practical impact of the new regime. Before we look at those questions, could you briefly give us some background on the purpose of the Legal Services Act?
Certainly. The key points behind the Legal Services Act 2007 are essentially to provide a coherent framework around why the legal services sector should be regulated over and above the level of regulation that applies to general businesses at law. The core focus around this is on things called regulatory objectives. There are 8 of them specified in the Act, and we have focused in particular, although each of them rank equally, on issues to do with improving access to services, improving competition in legal services provision, and making it easier for consumers to get better quality legal provision. The other regulatory objectives also cover important pieces such as improving access to justice and promoting and protecting the rule of law. This framework is really then designed to ensure that regulation of legal services going forwards meets these regulatory objectives and is effective for helping provide a better legal services environment going forwards in England and Wales.
Great. And against that background, could you summarise for us the respective roles of the Legal Services Board and the Solicitors Regulation Authority?
Certainly. The Solicitors Regulation Authority is one of 10 frontline regulators. The frontline regulators, or approved regulators in the terms of the Act, are responsible for looking after one of the branches of the profession, so the Solicitors Regulation Authority for solicitors, the Bar Standards Board for barristers and so on. Most of the regulators are actually a ring-fenced subsidiary, an independent subsidiary of a larger organisation, a representative body. So you have a representative body, the Law Society, within which there is a ring-fenced subsidiary responsible for regulatory activity called the Solicitors Regulation Authority. The Legal Services Board sits above the frontline regulators and ensures that they regulate in accordance with the provisions of the Legal Services Act, and also ensures that the separation between the representative functions and the regulatory functions is effective, so that regulation is only guided by regulatory influences and not by representative ones.
I see. And what's the relevance of all of this to in-house lawyers?
Well, of course, any solicitor or a barrister working in-house has always been regulated by the Bar Standards Board or the Solicitors Regulation Authority as appropriate. However, with the new outcomes-focused regulatory handbook, the duties are spelt out much more clearly for solicitors than they have been in the past. There is a section, Chapter 4, which deals specifically with in-house practice, and all of the other sections of the Code of Conduct and Handbook identify exactly where solicitors and separately solicitors managing in-house departments have duties going forwards.
So for solicitors managing in-house legal departments, what are the top 3 things that they should consider doing immediately?
Well, from the 6th of October, they should have read the entire new handbook. There's a lot of it, but it's clearly spelt out what applies to in-house lawyers and which bits do not. And so it's possible to work out which bits should apply to you. Having worked out which bits apply to you, you need to compare your current practice with that, and where necessary, make changes to bring yourself into compliance with the requirements identified in the handbook. It's worth remembering that this is very much focused on outcomes, achieving the right goals, and having processes in place to demonstrate that you've achieved those outcomes. So proper processes suitable to your environment, rather than prescribed centrally and perhaps not being relevant to your environment, leading to demonstrable achievement of the outcomes. The third thing is then to make sure you keep a track of what you're doing and stay up to date going forwards.
What are the reserved legal activities outlined in the Act?
Okay, there are 6 reserved legal activities, and these are activities which must be done by a regulated person, as opposed to general legal activities which are only regulated if you're a solicitor or a barrister because you're a solicitor or a barrister. The three key ones from the point of view of commercial people are advocacy, actually standing up in court, conduct of litigation, reserved instrument activities, which broadly speaking is conveyancing, but there is a bit more to it as well. And there are three others which are perhaps less relevant to day-to-day practice in most in-house departments, but they're notarial activities, administration of oaths, and probate.
Right. When an in-house team outsources any of those reserved activities, what, practically speaking, are the implications of that under the framework?
Well, with regard to the 6 reserved activities, they can only be outsourced to an organisation or individual that's an authorised person for those activities. Otherwise, the person doing the activities is committing an offence, and the person who is giving them the activities to do is breaching the solicitor's code of conduct. So that would normally mean that you'd be looking to a solicitor's firm, a barrister's firm, trademark agent, or whoever is an appropriate authorised person for that activity. With regard to the wider range of activities that are regulated because you're a solicitor or a barrister, the Chapter 7 obligations, the Outcome 7.9 and 7.10, require that you still outsource reserved activities, those regulated activities because you're a solicitor, to a competent party. And they also require that you ensure that that party has an audit clause in so that the SRA can inspect the work that that party does on your work.
In the situation where business colleagues are directly instructing law firms, what are the implications there? How should the in-house legal department remain compliant?
Well, the starting point with this is whether this is part of the established framework that you have agreed with your client, the business. Ultimately, you are responsible for ensuring compliant legal advice to the organisation in which you work. And so, if you have any responsibility for supervision of those areas, you should make sure that the work has been done, the instructions have been given, the advice has been received in usable form and implemented properly in the organisation to exactly the same standards as if you were instructing it directly. In other words, you need to ensure that there's a competent framework through which you can have confidence that any directly instructed work is handled appropriately in both directions.
Okay. Many in-house teams are looking at ways to empower their business colleagues to undertake work that might previously have been done by the legal team itself. What should they be bearing in mind when they're looking at those methods?
Right. The starting point with this is whether you are genuinely empowering colleagues in different departments and therefore are no longer responsible for the management and supervision of those people. If you're still managing and supervising them, then they're still part of the legal team regardless of what you call the heading, and therefore the code of conduct principles around managing teams will still apply to them. If they're going to be outside of your management and control, then the first thing to ensure is that they're not planning to do reserved legal activities, because it would be illegal for non-qualified people to do that, or non-supervised people in a qualified environment to do any work on those. The second thing is, if it is not reserved legal activities, then you need to ensure that whoever is doing the work is not going to create a problem for themselves, for example by being a solicitor working in the wrong supervisory environment in another department and putting themselves in trouble with their own code of conduct personally. The third piece then is that as you're responsible to the organisation for legal services provision, any outsourcing or empowerment of colleagues that's done must be done in a way that ensures that the work remains safe or competent.
Right, thank you. Another question we received was about about Chapter 7 of the handbook.
Yep.
And the SRA's duty of audit, right to audit over some suppliers.
Mm-hmm.
And the question was, which suppliers are those? And specifically, are international law firms or lawyers in other jurisdictions covered by that?
The Chapter 7, Outcome 7.9 and 7.10 of the handbook cover these areas. If it's a reserved legal activity, one of the 6 that I mentioned earlier, then you can only outsource that to a provider that's authorised to provide that particular reserved service, which would therefore have to be an SRA regulated firm or a barristers' chambers or similar. Other legal activities, i.e. the type of legal work that a solicitor would do but isn't part of that 6, must also be set up and outsourced in a supervised way according to the code of conduct. So that would suggest that overseas law firms, because they're performing legal activity, would also need to have that audit clause within it. As would any department or provider of services to your department, which is an important provider to your department and upon which your department is heavily dependent, which may be a non-legal provider altogether. So for example, an information provider, an accounts handling provider or similar, who are critical to the function of your department. And again, the code suggests that they should be subject to this audit clause.
Thank you. Another situation that some in-house lawyers find themselves in is that they're approached by business colleagues for personal legal advice, free legal advice on, say, conveyancing or probate issues. How should an in-house lawyer respond in that situation under the new regime?
In much the same way that they've always had to respond, essentially. The new handbook, in particular the in-house duties chapter 4, spells out quite clearly when an in-house lawyer or any other lawyer can provide advice. And in essence, it doesn't matter whether that's been provided free or for charge. The issues are about the client being able to rely on the advice given and have redress if things go wrong. Just because something's free doesn't mean it can't create issues. And depending on the precise context, it's likely from that illustration that you've given me that the Chapter 4 guidance would be that you shouldn't provide that advice.
I see, thank you. Another aspect of the new framework that's received a fair amount of attention is alternative business structures.
Mm-hmm.
And we had a question about just what are the pros and cons of setting up the in-house legal team as an alternative business structure?
Right, well essentially the pro and the con are the same thing.
Right.
The pro is that you're setting up a law firm. The con is you're setting up a law firm.
Right.
By which I mean that one of the good things about the outcomes focused regime that's just come in was that it was linked with bringing in alternative business structures. So now any traditional law firm or new alternative business structure, i.e. a non-lawyer owned and or non-lawyer managed firm, i.e. what your law department could become, both types of organisation will be under the same rule book. So the pros of this are if you incorporate a proper law firm, you can provide services to other organisations, you can help to bring in revenue to cover your costs, perhaps work more easily with joint venture partners, and your relationship with issues like privilege and advising your client business in a privileged way will be eased. The cons, if you like, which are not really cons, they're just the flip side of being a law firm, are that you have a higher compliance duty. You're running a law firm, so things like the ownership and management principles and fitness to own tests will apply. Client account money handling rules might also apply. So in essence, it's providing you with a facility to run a legal firm, but also the consequences of that.
I see. One situation that someone asked us about is if the legal team is asked by a non-group company to, say, run a session on the Bribery Act, followed by some questions and answers. Is that permissible under the new regime if you aren't established as an ABS?
The illustration you've given me, it does not hit that list of reserved legal activities, so there would be no statutory reason why that couldn't happen. The Solicitors Regulation Authority Code of Conduct specifies certain criteria around activities which are regulated because you're a solicitor, such as providing that kind of legal advice. And in Chapter 4 of the handbook, it identifies the circumstances where that advice could be provided or not provided, and the constraints such as carrying insurance that would be needed. It would depend exactly on the relationship between the different firms and the nature of the advice to be given, but it's all reasonably clearly spelt out within the rules and the guidance associated with it.
Right. And if the legal team decides it does want to set itself up as an ABS, what are the steps to doing that? How do you achieve it?
Fortunately, this is all pretty clearly documented now. The starting point is to look at the Solicitors Regulation Authority or Counsel for Licensed Conveyancers information about how they process applications, what they expect from applicants, both in terms of applying and then in terms of running their ABS organisation. At this point, the Solicitors Regulation Authority still has not been authorised yet to supervise alternative business structures, but it's expected that that will become the case early next year. Second thing I'd recommend is then to look at Part 5 of the Legal Services Act and Schedules 10 to 14 and the related guidance that we, the Legal Services Board, have published on our website. That will give you the wider framing and understanding of what it is that's been sought to be achieved and why. And then finally, I'd recommend that if you are going to progress seriously, having done your business cases and analysis, you then go and talk to the SRA or the CLC as appropriate early to get an understanding from them of how they're likely to handle your application and issues and concerns that they see, so that if you do choose to apply, you make a competent application which meets all the criteria that they need to see addressed in the application.
Great, thank you. We spoke earlier about various ways of practically complying with the new framework, and I wondered if you could give an illustration of the focus that regulators have on in-house lawyers and the potential impact of getting it wrong, of not successfully complying.
Absolutely. It's worth remembering that the benefit of being a solicitor in-house, and there are roughly 20 to 25% of solicitors and barristers now do work in industry, and we're apparently responsible for around 50% of the spend of the £24 billion a year that's spent in England and Wales on legal services. So it's a big and influential community, and therefore one which rightly has responsibilities attached to it. And in that context, the regulatory handbook is now very clear. It says what you need to do, both as a manager and as an individual within law functions. And it is important to get that right, because the SRA may investigate you in future, and it would be very unfortunate if either you or one of your team was prosecuted or threatened with prosecution for practicing when uncertificated, which is a criminal offence. And in that context, it's worth bearing in mind that apparently around 100 investigations were commenced by the SRA last year on in-house legal departments.
Wow.
So it is something that's worth getting right and worth taking the time to understand and do properly, not just because of the importance of things like ensuring you actually have legal professional privilege, but also because, you know, for the regulatory advisor to an organisation, also known as the law department, not to understand the legal framework applying to its own department would seem a bit foolish.
That makes sense. One more practical situation. We received a question from a sole in-house lawyer who doesn't have any managerial responsibilities. Would a person in that position, is there any impact of the new regime on them? Are there things that they need to be bearing in mind?
Yes, I mean essentially a sole practitioner, whether in-house or working as a one-person law firm, still has to comply with the handbook. The difference is that they are both the firm and an individual in one. So they have to read the handbook both as I am the law department and I am an individual within the law department, and cover both pieces. Fortunately, most of the handbook spells out quite clearly what the managerial functions are in running a law department or law firm and what the individual duties are. So you can work out what you should be covering in each area. But essentially, one-person team, 10-person team, one qualified person with unqualified people under supervision, the framework still applies.
So one other topic that's come up from the in-house community is what happens when you have foreign qualified lawyers within your department. How are they covered by the handbook, and what are the key practical steps you need to take to ensure you're compliant as far as they're concerned?
Right. This is a complicated area. The first thing is that within the SRA handbook there are three categories of lawyer recognised: domestic lawyers, solicitors, registered European lawyers or RELs, and registered foreign lawyers or RFLs who are from outside of the European Union. In each case you need to understand which classification the individual who is working for you has, and then look at the work that they're doing and whether the work has been done under supervision or has been done independently. If somebody is working under supervision, then to the same extent that a paralegal under supervision or an administrator under supervision is working for you on a matter, there would generally be an assumption that things are heading in the right direction because they're closely supervised. But if they're starting to do work in their own right, then you need to start considering whether they're holding themselves out as a solicitor under English and Welsh law in their advice. And that gives rise to concerns about whether they're properly qualified or not. But also you should have regard to it from the point of view of things like whether they're performing reserved legal activities when not qualified to do so. That list of 6 I mentioned earlier, like conduct of litigation or advocacy or conveyancing. And also from the point of view of things like legal professional privilege, because of course legal professional privilege is a function being regulated in the right jurisdiction for that privilege. English legal privilege comes from being an English qualified lawyer and so on. If your lawyers are not English qualified and are identifying clearly that they're not. For example, New Zealand qualified attorney is the note on the footer of the email and all communications. That may be fine within a particular structure. But if you do want to bring those lawyers into qualification, then it's worth remembering that the QLTS or QLTT, the Lawyers Transfer Scheme, identifies the criteria through which they will have to pass in order to be able to requalify or dual qualify as an English qualified lawyer. And that varies by country depending on the level of qualification and comparability of that qualification with the English qualification. And that exercise is quite a substantial one depending in some jurisdictions. So it's worth understanding that fully before either taking on a lawyer from those jurisdictions to do English law work or committing to transfer someone into the regime who you already have.
Thank you. And another topic is how the framework treats pro bono work. So work that's done free of charge and by a qualified lawyer. How does the framework apply to that?
Right. Well, it's worth starting off from the premise that the legislation is all framed around consumer protection and looking after the rights and interests of consumers. And therefore what the Act is seeking to do is to ensure that whether you pay for the advice that you get or not, the advice is competently provided through a suitable framework and with adequate insurance in case things go wrong. That is the setting within which the discussion progresses towards two things. The first one is reserved legal activities, that list of 6. And in that context, the Act is clear that providing reserved legal activities to a member of the public as part of your business, which could include pro bono as part of your business, would require not just the lawyer but the firm in which or department in which they're operating to be regulated. So by implication that would mean that the department would either have to be an ABS or find a mechanism through which the individual lawyers could work through another regulated body for their pro bono work. Outside of the reserved legal activities, the Solicitor's Code of Conduct again spells out quite clearly within Chapter 4, the in-house section, how the pro bono arrangements can work if you are doing general non-reserved legal activity, but activity which is regulated because you're a solicitor. And in that context, again, the principal requirements are around protecting the consumer by ensuring a competent supervised environment and appropriate insurance. But it's all spelled out quite clearly within the handbook.
You said in the first part under reserved legal activities, pro bono work that could be part of the business. How can the manager of an in-house team determine whether pro bono work actually is part of the business or not?
The SRA has provided some guidance as to characteristics that might reflect something being part of the business. There are no absolutely black and white tests on this, but essentially it would probably the viewpoint to take is looking at it from the perspective of the consumer of the services, whether they would understand that the advice was being provided by the individual lawyer in their own capacity with their own insurance and protection, by that individual lawyer as part of a voluntary group or other body which has the right protections in place, although the individual has been loaned to that body by the company, or by the company itself. And if it's in the company's case, then the expectation is the company will have the right arrangements in place so that the individual, thinking they're getting the legal service, albeit for free, from the company, can be reassured that it's a competent framework of provision of that service, and if something goes wrong, there's redress.
Thank you, Bruce. Those were some really interesting insights, and thank you for your time.
Okay.
Thank you.